like Jackie mentioned, we're going to be talking about some of the big, dangerous contract clauses that may pop up in the contracts you sign. I want to say thank you to everyone who is joining us today. Some of this may now be relevant given the ice storm Houston had last week, or actually the entire state of Texas, I guess. So we're going to move through this as I have some examples from, my actual cases that I've dealt with in the last couple of years. I will start to bring those up so you can kind of get real tangible, a reality of what this can mean for you and your business depending on the different types of documents you sign. So first we'll start with the contract documents. And so what are you agreeing to? What are you signing? And you purchase a fridge, you get a car loan, you sign a whole bunch of different documents, and you know that anything you've put your signature on, you're agreeing to what's in that piece of paper. Now, the tricky thing that happens in a lot of construction projects is you are in fact agreeing to more than what's in that subcontract that you are signing. And the biggest thing that we see is the inclusion of the prime contract. So first you have your 10, 15 page subcontract. It may have your scope of work, it may have the price, may list the different parties in it, things like that, the typical things you're used to. But what you may miss is a line that says, oh, this also incorporates the prime contract. This incorporates the plans, the specifications, or the project schedule. Now, a lot of times what you'll see in the first couple pages of your subcontract is you'll literally see a heading that says contract documents. Whatever is under that heading, or if you ever see reference to anything else, you need to go get those documents. So what is a prime contract? You'll hear this term in a couple different ways. It'll be called prime contract. It might be called the original contract, but it's the contract that's between the owner and the general contractor. And if it becomes incorporated into your subcontract, you are now going to be responsible for any of those terms that it essentially is getting pushed down to you. The general contractor is kind of shoving liability down while still getting all the money from the owner. So you won't be able to sue the owner directly for breach of contract, and you don't have that constitutional lien right by saying you have a direct contract with the owner. And we know this because we've tried it multiple times in different courts, making this argument of, well, you're telling me it's incorporated and now I'm bound to terms of a contract and I can't even sue the other parties to this contract. And so that's why it is so dangerous, and that's why you always need to get a copy of it. So don't just sign, don't just assume that what's being used is the AIA form for a prime contract. Don't assume that it only applies to the owner and the general contractor. Get a copy of it. And you can add language to make sure that you are just getting not just the responsibilities of the prime contract, but also the benefits. That might be a little bit case specific. I can't give you an easy sentence or an easy paragraph to throw in there, but contact us. Like, we'll be able to look at, what is your trade? What scope do you have? And to be able to look at what is in the prime contract to create something that'll make sure you are protected both ways. So the other thing that could be part of your subcontract is the plans and specifications. And this is the directions on how you build the project. The scope of work is, the plans that you're going to follow. Your scope may be, let's say, to install all the windows, but where and what size, and are they different types of glass, things like that. That's all in the plans. And so let's say you're like, oh yeah, I install windows, but maybe now the plans have specified for, let's say, fire rated glass, and you don't do that. Well, now you're kind of stuck. Now, what do? Do you just say, no, why would I ever agree to that? Because that's not what I do. Or do you have to turn around, go buy fire rated glass from somewhere else, or, get someone to come install it for you? Now you're kind of in a pickle here because the plans added extra specifications that are not necessarily what you do. And to give you an example for this one that I had just recently, I had a client bid for a certain type of landscaping, and they knew what they were doing as far as certain pieces around certain buildings. And yet when it came to the actual plans, it added, I think it was probably 3 times as much work that had to be done. And so that created an issue for my client because the price was too low. They didn't know how to do certain landscaping work. And now they were kind of in this issue here of either they're getting fired off of a project or they're having to eat all these costs to fix everything. So what you need to do again is to make sure you get those plans and specifications. And what's tricky about this is these things change. There could be change orders, there could be requests for information where now maybe an architect is changing something. So get everything in writing and make sure you're staying up to date. I know a lot of these bigger projects offer things like portals where you can go in and see new iterations of plans and specifications. Make sure you're keeping up with that, and that it's matching up to what is in your subcontract and your pricing, and if not, asking for the appropriate change orders. So it has to be a very hands-on evaluation of what's coming down from the top of the project down to you, not just you managing your people and your scope on the project. So the next thing to look for is the project schedule. What's the timing of it? It's better to get something done faster than anticipated than having to push up against that deadline. And that's because of these liquidated damages and delayed damages that could be in your contract. Now, what's an excusable delay, what's not, that also can depend on other terms in your project. And so we've seen issues with that. If anyone was on any projects during Hurricane Harvey, it could be a weeks long delay. It could be a couple of days or a week, the way we had last week with the ice storm. What's the reality of that? What's excused? What's not excused? And if you're coming up against other terms in your contract that isn't excusing a lot of things. For example, acts of God, like an ice storm in Houston, Texas, isn't being excused. Well, the way you can protect yourself, instead of negotiating maybe that specific term, is you negotiate a longer time to complete your scope of work. So now you have this buffer for if an ice storm, if a hurricane, if something happens, that you can breathe a little bit and not have to worry about these delayed damages, which can be little or could be thousands of dollars a day. I had a case where I was involved with a bunch of subcontractors on an apartment building with a owner and a GC, and this was a $60 million project, and the delayed damages against my client as a subcontractor alone. Now, I'm not saying there was any evidence that my client caused the delay, but they calculated it as a $1.6 million out-of-pocket expense against my client. And so if liability had been found that we were the ones that caused the delay, then those damages become part of a judgment against my client, which can utterly destroy a subcontractor. So that's why these are so important, and that's why the project schedule is so important for you, because the domino effect, if you get into one of those situations that is completely outside of your control, then you want to be able to be protected. So the next thing you're going to look for, is what is not included in your contract documents. And what you're going to look at is the comparison of your scope versus your estimate of or proposal. So typically a heading we always see in subcontracts is the scope. All right, what are you doing? Sometimes it's super vague. So an example I can give is I had a client and it just said all fire rated glass. Great, that's what my client does. They can get them, they can install them, great. However, the problem was the scope said all. So what did all mean? My client interpreted all as the bid, and the bid was for 12 pieces. That price was for 12 pieces, it was great. Well, what got put into the subcontract was the price for 12 pieces. However, the scope was for all. And all meant going and looking at all of the plans, which was not 12 pieces, it was 39 pieces. And so now my client is doing triple the work for pennies on the dollar in order to prevent getting fired or delay damages or things like that. Now, it was a situation where we were able to work something out, but they had to get lawyers involved that only upped their cost, and then they were going to have to eat some costs possibly on the project, and things like that. And so this estimate, your bid, whatever you've done to get the offer, to get the contract document into your hands, you're no longer bound by that. That kind of gets thrown out the window. And now what you are signing is going to be the active document, the living, breathing document that's going to kind of control everything you're doing. The other thing that's never going to be included in your contract documents is verbal agreements, things that are not in writing. Most contracts specifically state verbal agreements will not be allowed to modify a contract. The contract itself would be the only agreement, and that's why change orders are so important, because a lot of these contracts have a term in them that says there's no modifications to this unless it's in writing and signed by both parties. And that's what a change order is. It's essentially a modification of your contract that is in writing and should be signed by both parties. It even gets to the point that in our, we go to court and we're arguing about terms of a contract, there's actual evidence rules that says other verbal agreements, other conversations don't get brought in as evidence, and it's called the four corners rule. The only thing we look at is what's inside the four corners of that piece of paper you signed. And so, you know, promises from someone up or down the chain are great, but at the end of the day, they hold no weight when your back is up against the wall for a variety of reasons. So now that we know the pieces of paper that are going to be controlling, let's now look at what are the important pieces inside that could get you in trouble or that could be dangerous. Now, these are some of the most common ones we see. Every type of project, every type of trade has different things that could affect them. So don't only look for these 6 and think you're good or that you understand. These are some of the top ones. You know, it's always important to read every word of your contract, highlight anything you don't understand, and come to us and let us either tell you, oh, no, you're fine, or hey, we need to really negotiate this, or you need to really be aware of what this says. So the first one is going to be back charges. Now, back charges are kind of similar to delay damages in that it costs you way more money than just actually doing the work. So these subcontracts allow the general contractor to charge you for items you didn't finish, you didn't do right, or damages you caused at the project. And so typically that amount is going to be much more expensive than you just doing the work yourself. And obviously that's because if you are, let's just stick with windows, if you're doing windows and you manufacture those and you're doing that at cost, and your cost is basically labor, getting your guys to go out there, well, now the GC has to go hire company B, and they have a premium on all of that stuff for profit that they're charging the general contractor. That cost is just getting passed along to you. And now the GC is not rehiring someone to fix your work. You're essentially hiring someone to come fix the work you could have done yourself. And so that's allowed in these contracts if that clause is there. So even if you disagree with what the general contractor is telling you, you think you've done it right, you need to fix what needs to be fixed, because you can prevent that sort of exponential damages. You fixed it, you're not getting fired off of the job, and you have still reserved a way to now go after the general contractor, or after someone else if necessary, to recoup, you know, that little bit of extra money you had to spend going to fix something. So by fixing it, legally you have not cut off any way to recoup those damages, but what you've instead done is you have saved yourself probably exponential damages in the situation. So if you feel like it's something you shouldn't be held responsible for, put it in writing, say why, say what you've done, but always come to an attorney. We can put that in writing for you. We can help evaluate the situation, because at the end of the day, when it gets to something like this and maybe it feels risky, we can help you make that business evaluation, right? You don't want to get into litigation where you're paying a ton of attorney's fees, especially if you're defending. Any of you have been in a lawsuit where you're the defendant, it is much more expensive. Not only are you paying your attorney's fees, you probably can't get your attorney's fees back from the other side if you win. You hope you have leverage, but you don't always have leverage. And so that's why it's just kind of better to be proactive, know that clause is there, know what it could cost you, and do everything you can to avoid back charges. So the next clause you want to look at is this termination for convenience clauses. So why, how, and when can I get fired off of a project? So a sample of some very dangerous language is that you can be terminated hereunder at contractors' convenience. So for whatever reason they want, they don't like the color of your hair today, they don't like the truck you drive, they don't like the shirt you're wearing, they can just kick you off the project. For any reason, for no warning, no timing, anything like that. Obviously, not the way you want to be practicing your business. Doesn't make economic sense. So what you want to look for, and what we see is common, but we have seen it absent from a lot of subcontracts, is you can only be terminated for cause. Okay, well, what does that mean? So hopefully your contract then also has a list of what for cause means. And it can be, you failed to show up 3 days in a row, or you caused damage, whatever it might be in there. And paired with that, you also want to see that whoever you have your contract with, whether it's another subcontractor or even the general contractor, they have a notice requirement. They have to give you notice of what is wrong, and they have to give you a certain period of time to fix what is wrong. And so that is the period where you would go in, like we just talked about, fix the issues so you don't have the back charge, and you fixed it so now you're not terminated because you stepped up, you did the job, you responded to this notice, you were kind of put on warning. This isn't just they woke up on the wrong side of the bed, don't like you anymore, you're off my project. It gives you some sort of protection to know that you're going to continue to be employed on this job. Not only that, it prevents all the other consequences that may flow from being terminated from a project. There can be a lot of them. Back charges was just one of the ones we talked about. So look for terminations with convenience clauses. The next thing is waivers and releases. Texas established in 2011 4 different types of forms. That's what they are. They are fill-in-the-blank forms about releasing your right to payment or waiving your right to payment and things like that. So these are things that are used if you are being paid progressively during a project. You every month, let's say maybe you get paid, or at certain checkpoints in the schedule you're getting paid, whatever it may be, however you're being paid on the project. There's several different types. So the first one is a conditional waiver. So it's filled out and submitted with your progress payment applications. And what the condition is, the waiver takes in effect on the condition you get paid. It's a pretty simple one. It's honestly a pretty safe one because it doesn't become enforceable until you're paid. You still retain all of your rights, all of your litigation rights, whatever rights you may have under the contract, up and until that check clears your bank account. Once it does, you waive your right to that payment. Makes sense. You got paid. You don't get to get paid twice. The second one is an unconditional waiver upon progress payment. Should be provided to the GC after the check has cleared. So the difference between this one, the unconditional, and the conditional is the timing. When did you sign and when did you get the money? If the contractor walks up to you and hands you a check and it clears, great. The next day, turn around, give them this unconditional waiver because you've been paid. There's nothing to wait on. There's nothing to worry about. You're not worried that the check gets lost in the mail or that it bounces or anything like that. This becomes effective the moment you sign it. And so this is the one to really, really look out for, because anything that says unconditional, look at that amount, compare it to the check. Don't give that away until your payment has cleared. Because let's say you sign off unconditional waiver, no problem. Then you never get paid. So sorry. You have just thrown that money out the window, flushed it down the toilet, whatever analogy you want to use, you waived it. You agreed to say, I won't claim this money anymore. And so just pay attention to that. It's literally 2 letters on the form between conditional and unconditional that could really mess with you. So pay extra attention to that. The third one is a conditional waiver upon final payment. This differs from the first one, the conditional waiver, because it will have more terms in it because it's a final payment. It's this idea that you are completely done on the project. You're not expecting any more progress payments. You're releasing from now until forever your right to get money in conjunction with this project that you are working on. Operates the same way as the first one. It's only going to be effective once you get that money. It's just that what you are waiving is much more. It's everything that could have been left on the project. So again, before this is signed, make sure it's the right amount, make sure you are truly done, that you don't think you're going back for additional punch lists or repairs or anything like that. The last one, conditional waiver on final payment, very similar to that second one we talked about, should never be anything that is signed and provided to a GC until you have that money cleared. Again, once you sign it, now you are done claiming any money for this project. And if you do that before you have received payment and you don't get the payment, there's not a lot of remedy that you can have at that point, because you basically said, I've been paid everything, I'm not owed anything, I am done with this project, I'm never going to go back to it, I'm never going to claim money from it, I can't litigate on it, nothing, you're done. It's some of the strongest waiver language allowed under Texas law. So again, be so careful about timing and if it's conditional or unconditional. If you have any questions, we're always here to it's a quick answer because we deal with them all the time. So it's worth that phone call to just make sure that you are submitting things in the right order to make sure your payment is protected. The next clause are these flow down indemnity clauses. Now, if you have any familiarity with indemnity, basically it is an owner, a general contractor, someone above you on the chain pushing down liability to people lower than them. So let's say the GC has done something wrong, but somehow it's also your fault. Well, the GC will pay the owner to keep the owner happy, and then the GC is going to turn around and look at you and shake their finger at you and say, it's your fault. You're the reason I had to pay the owner. Now you need to reimburse me for those expenses. So again, GCs do everything they can to push the liability from all aspects down to the lower sub and the subcontractors. So basically, they will be as strong as Texas law allows. Texas law has done what it can to limit these to only things that are stemming from your actual scope of work. But I have a real life example of something that a lot of subcontractors just don't think about. And it's your relationship with your employees and this idea that they could be injured on these jobs. And so for a quick example, you've got a guy, you're out on a project, let's say you are a painting company, and this guy's up on scaffolding and he falls and gets hurt, comes to you. well, you didn't erect the scaffolding, you're not really in charge of that, but you got workers' comp, so no big deal, he gets taken care of. Well, that employee now turns around and he sues the company that put up the scaffolding, he sues the GC, he sues whoever he needs to for not creating a safe work environment, right? Because he can't sue you, workers' comp, took care of all that, you're free and clear. So he goes and sues the GC. The GC is liable, makes sense. But because there's a flow down indemnity clause in your subcontract, even though workers' comp took care of everything, and now the GC had to pay this employee all of this money for injuries or hospital stays or whatever it may be, that GC can turn around and get that money back from you, which is wildly unfair. I don't like it. It's a workaround the workers' comp laws, but it's there and it's enforceable. Unfortunately, I have read many Texas cases allowing these types of clauses for serious injuries or even deaths by employees to go all the way back down to the employer. So look for things like that. My recommendation is to negotiate especially that one out. But the biggest thing with indemnity clauses is for you to be aware that they're there. If you're not aware of every piece that's in your contract of all these different things we're talking about, you're not able to fully protect yourself. You might make a different decision if you know that this indemnity could come back to you, that you're going to have to turn around and reimburse these different people up and down the chain. So by knowing that it's there, you can better protect yourself on the situation, and maybe you don't use workers' comp in this situation. You reach a settlement agreement with your employee that waives their right to sue anyone, and now you've protected yourself. We have a lot of options. You just need to be aware that these clauses exist so that we can better protect you when incidents happen. So the next thing for us to look at is insurance. A lot of people I know look at this and they're like, oh great, insurance, we're covered, no big deal. They're very common, commercial general liability, you see them, but the problem is the exclusions. Sure, a lot of us are going to have a lot of insurance dealings in the upcoming months because of last week. We have all faced it, whether it's been medical or car insurance or home insurance, about exclusions. Same thing applies here. So not only do you need to know what policies are incorporated into your contract, but what do they say? So if we look at the next slide here, most policies are boilerplate language. They're general, they're vague. It extends to, basically what the insured is legally obligated to pay. It'll cover things like bodily injury, what was the occurrence that happened, is it covered? The occurrence also, it's very site specific. What's the address of the construction project, things like that. And so, read it. They're all pretty general. That's not going to be a different thing really project to project, but what is going to be different is these exclusions. So if we go and look at some common exclusions, you need to look at it's written down. They should be there. They should be clear what is excluded from the policy. And so what the policy is for these kind of unpredictable events, right? These third-party events, third-party claims, not necessarily other people's own bad work. And so there might be coverage for defective work performed by the subcontractor, but it also may not be there. So for example, I have another client who were doing work on a surgery facility. It was this plastic surgeon facility, and they had hired a subcontractor to do the HVAC work. And this subcontractor, instead of lining the ducts externally, they lined them internally. So as air started to blow through these ducts, fiberglasses and all of these things were being blown into surgery rooms, things that were supposed to be sterile. Obviously, huge problem for a variety of reasons. But the insurance policy, so pursuant to the contract, the subcontractor had an insurance policy, but it did not cover defective work. It only covered damages as a result of this defective work. And so the problem here is when my client then had to go back in and take out and redo all of the HVAC, lift the roof, all of that, none of that was covered by the insurance. What was covered is the cleaning of the surgical rooms, trying to get fiberglass out, any damage that may have been done to medical equipment, any leaking that may have happened, that was covered. But that may have been 10 to 20% of the damages incurred by my client. And so now my client isn't done. They still have a way to go get their money, but now they're going after a subcontractor that's basically defunct, and there's no bank there to go get their money. So this policy was not general enough to kind of protect the issue that my client was facing. It was not something that was ever beneficial because of this named exclusion, that the effective work was not covered. So that's another thing to kind of be aware of. You need to make sure you're reading the policies, what is being excluded, what's being included, because again, maybe you can't go negotiate an insurance policy that a sub or general contractor has on the project, but you can alter your actions, or you could change the way you react in certain situations, knowing what the implications down the line may be. Being armed with information here is the most powerful thing you can do on these types of projects. So the next thing is our primary coverage. And so typically you have a lot of policies happening on a construction project because the general contractor probably has an insurance policy as required in their prime contract. But they've now required you as a subcontractor to also have a liability, policy. And let's say you're the drywall. Now they've also required the painting sub to have an insurance policy, and they've required the electrical sub to have an insurance policy. So who pays? And what happens is all of these insurance policies, if you've ever dealt with them, no insurance ever wants to sign a check. They never want to pay any money. And what they do is they all sit down, they hire their high-priced lawyers, and they become bumps on a log, and they just point their fingers at everyone. And when they all get involved, it starts to be expensive. They start making your lawyers spend their money trying to get information for them, who's at fault, and they all just sit back and be like, nope, not me, I didn't start the fire, basically. So how do we prevent that? How do we know who is the primary coverage, who pays first? And so what you want to do is you want to require all policies down the chain from you, or even across the chain from you, to make sure that they are, as much as you can, primary insurance. If it becomes that, if they're really all primary, there's not going to be this waiting game of finger pointing and things like that. So what you need to do is you need to confirm that you have an adequate coverage. You need to review the actual policy, and you need to look at not just yours and the one above you, but also the ones below you. Just looking at the certificate of insurance is not enough. That a lot of times will tell you policy limits, but it won't tell you policy exclusions. It's boring. None of us like insurance, but you need to read it. Or have your friendly Cromeans law firm attorney read that for you and give you the highlights of what you're looking out for. So once you've received a third-party claim, or you've been sued for something that might be covered by your insurance, you need to get that to the insurance carrier ASAP. They're slow, they take forever. You need to get the ball rolling as soon as possible, because then they begin their investigation. Especially if it's a situation that is not just someone's messed up on the project, but is an act of God, aka an ice storm, and you've got a pipe burst, or you've had whatever happen. Insurance adjusters are going to be spread thin, so you want to be first in line. And so you need to get all the information you have, be as responsive as possible to your insurance carrier, let them into the property, let them come investigate, let them inspect everything that's happened. Once that investigation is complete, the carrier informs you of its decision. If it's a denial, that's not the end. Just don't take the insurance company for their word, because they could be doing what we've just talked about, and their denial could basically be, oh, we're not the primary insurance, I'm pointing my finger over here. That doesn't necessarily mean you're out of luck. You may need to contact an experienced attorney that can kind of tell you no. They're saying no, but they're not really saying no. Or, hey, it's very clear this isn't something that's going to be covered, but here's an alternate way you can go about maybe recouping the money from this loss. So the next thing to look at is arbitration and mediation clauses. These are important. They're very common. A lot of people don't know the difference between arbitration and litigation. So arbitration comes out of the court system. It is an arbitrator is selected between the two parties. It's typically someone that has many years experience in the construction industry, which is good. Typically it's an attorney that's fought these types of cases on both sides, so they know the law and things like that. However, it's very expensive. And the reason it's so expensive is arbitrators are paid like lawyers are paid. So let's say you're paying me, $200, $300, $400 an hour to litigate your case, and I keep having to get the arbitrator involved. They keep having to read all of my documents. They keep having to make decisions. We have hearings, we're arguing. Now you're paying for the arbitrator's time as well. And I guarantee you, because they're so expensive, or experienced, they are expensive. So their rate is probably $500-$600 an hour. Typically you do split that with the other side, but you're basically paying 1.5 times as many attorney's fees as you ordinarily would. Not only that, just the deposit to get the case started could be $10,000 or more. And so you can see how it gets really expensive. You can also see why a bigger company does this. And I have seen that be kind of twofold. To me, it's very much a bullying tactic. They have the money, they don't care, and they're really just calling your bluff that you don't have the money to push this to arbitration, and they just hope you let it go, because they could just do you wrong day and night, but you won't have the capital to go fight them on it because it's so expensive, versus being in the court system, where you file your lawsuit for $400 and you're not, other than your tax dollars, you're not paying the judge, to listen to us argue or to make decisions and things like that. So that's one reason. The second reason is that prevents you from having a jury. And a jury typically will side with the little guy, right? They're people who have worked their whole lives. If you can get a good jury of, good, hardworking people, they're not supposed to have bias, but they will likely side with you as a smaller subcontractor. And so that is why these bigger companies put these clauses in, and they're expensive. And again, even if it's not something that you can negotiate, it's definitely something to keep in mind, because it'll change the way you react to different situations that pops up during the scheduling of the project. The other piece is there's mediation clauses sometimes requiring you to go to mediation before arbitration, or requiring you to go to mediation before you file a lawsuit. Mediation is something that happens in both arbitration and litigation in a normal courtroom. It's informal. It costs, somewhere between $900 and $2,500 per party. That's the fee that you pay to the mediator. Then, of course, you have attorney's fees for prepping and sitting there all day. But it's not binding. You get to sit there, you get to kind of reach, maybe it's not a typical legal resolution, but it's something that is out of the box and it fits you, your business, the project a little better. Maybe it's oh, I can't pay you right now, but I'll go ahead and assign my accounts receivables of this next project that I have, that I've already signed, that I've already started work on, and you get paid that way. That's not a resolution you would get in arbitration or litigation. Kind of lets you be outside the box. And at the end of the day, if you make it to the end of the day and you have an agreement, you both sign it, great. That settlement is binding. If it's clear that they're just there offering you pennies on the dollar and you want to walk away, you can walk away. A mediator has no goal other than to get you to settle. And so they can't make a decision, they can't do anything. Everything's in your hand. It's a very common tool used for settlement. It's also a common tool where you start to kind of get the other side's arguments or positions, or things like that. And sometimes I have found out very surprising things at mediation that didn't come out, through other avenues in a case. So it can be beneficial, that's not necessarily a clause to be worried about. It's definitely a better option than arbitration, but it's a clause to be aware of because you found yourself to that. And so sometimes going to mediation is not always the best route in a case as far as settlement. For example, I have a case where there's a defective concrete. So did my guy supply defective concrete? Did the mixer do it incorrectly? Did the person who poured it do it incorrectly? Did they not wait for it to cure the appropriate amount of time? Who's at fault? I'm not just going to go to mediation without knowing some of those answers, because those answers are my leverage to keep my client from having to pay a bunch of money. So, mediation is not, in this case, something I am willing to do super early on. I want to collect some more information, some more data before doing it. So that's just something to keep in mind when you agree to a mediation clause, is sometimes they kind of force you into some sort of settlement negotiation without the ability to kind of do a fact-finding mission, and it's kind of just up to you to hopefully have the right documentation to help give you leverage at it. So those are a couple of clauses to be aware of that a lot of people just kind of skip over. So I think now, Jackie, correct me if I'm wrong, but if you guys have any questions, again, I know that was fairly quick, and again, those are just the common clauses we see. So any questions? I think we got about 15 minutes. Feel free to jump in.
Yes, yeah. So anyone feel free to unmute yourself and ask the question, or if you want to put it through the chat, I'll read the question off to Kelly from there. But yeah, any questions that y'all have in regards to your contracts, anything that, Kelly touched on that you want to clarify, now is the time. So Kelly, one question that I often see while we're waiting for some to come in is in regards to that unconditional lien waiver upon final payment. Do they wait to sign that till after they've received retainage? How do they handle that with retainage?
Yeah, so that's a good question. Again, that kind of all depends on the timing and what are you waiving. And so if it's a situation where there is retainage being withheld, then that would be considered your final payment. And so you would not want to waive anything until you get that payment. So you're doing a comparison with final payment of final means final. And if there's anything that's left on the table, then do not sign it. You could instead do an unconditional waiver for that last payment only, knowing that retainage is still coming, and then you could do a final release at that time. But if there is still a potential for money on the table, never sign anything that says final in it.
All right, thank you. We had another question come in from Sam. He wants to know, how do you deal with issues related to concurrent delay?
That's a great question. That depends a lot on what's the delay, what's in your contract. That's a very, very fact-specific question. I need a little bit more details of the actual situation to be able to give an answer. If by concurrent delay, you're meaning that there might be several subcontractors creating a delay, you know, in that case that I was talking about on the apartment building, that was that $60 million building with, I think in the lawsuit, there was probably 12 or 15 subcontractors that had gotten dragged into it. There were multiple experts hired and retained that looked at the schedule, compared it with when everybody was on the project, what everybody's trade was, and factored in Harvey, because a lot of these delays did occur back in 2017 with Harvey. And an expert went in there and started attributing the phases of the project to each trade and how many days each trade contributed. So it's a very expensive thing if you get all the way down the line to that sort of situation where you're paying a high dollar expert to go in and do this analysis on who did what and when they did it to figure out who truly contributed to the delay. That case was insane. I'd say hopefully that case is not the norm, and maybe it's only one or two people involved, or maybe it's just you're involved plus a weather delay or plus a act of God, something like that. That may be a little easier to figure out, but these things snowball. So when Harvey happened, after, you know, it's done and there's power and people are able to work again, well, now we have a shortage of labor. So whose fault is that? Is that the fault of this act of God, or is that the fault of my client who couldn't get enough people to come into work to continue to paint? So I'm sorry, that's kind of a squishy answer, Sam, but it's a very fact-specific issue, and that can become a little bit more expensive trying to figure out who is actually to blame in the situation.
All right, thanks, Kelly. Another question here, what is your advice for a termination for convenience clause? So maybe there is a termination for convenience, but you know, how can you make that fair to the subcontractor and provide fair compensation? I think that's how they were wanting the question. Let me know if y'all were wanting something different, but I think what they're asking is there a way to get fair compensation to the subcontractor if there's a termination for convenience clause?
Yeah, that's a great question. And so if that's in there and if that has been signed and you've started on the contract, then no, because you agreed to that, right? You've agreed that at any point you can just get kicked off the project. What you would want to do is negotiate it before it's signed. And you know, we have had a lot of situations where we have done contract negotiations for whether it's a master services agreement or a subcontract. And sometimes we're honestly surprised with what they'll agree to. And a lot of general contractors and people up the chain have just gotten used to putting in these things and hoping no one, you know, puts up a fight about it. But if someone does, they're like, yeah, okay, you know, sounds good. So you can't always guarantee what that type of response is going to be, but you definitely have to make that ask at the beginning before you signed on the dotted line. You know, I can kind of equate it to this idea of you get a hospital bill and they just hope you won't ask questions and they just hope you won't ask for itemization, and you know, and then when you do, when you actually push back, you get, you know, things taken off your bill, or you're ending up paying a lot less, or you know, the squeaky wheel gets the grease. And so you just got to do that kind of at the beginning. I understand that that's a little tricky, especially when this industry is done with a lot of you know, by the word and good reputations, and you don't want to kind of seem ungrateful or nitpicky or anything like that. And sometimes that's the literal advantage of a lawyer, just having two lawyers talk to each other instead of the parties themselves. So that can help you out as well. But just kind of approaching it in that situation of if they won't budge, you either need to understand you're accepting that risk, or you need to move on and not sign on the dotted line if that's not really what you, how you want to conduct your business or your project.
Thank you, Kelly. All right, do we have any other questions? We'll wait a minute or two for a couple other questions, but in the meantime, I did want to mention, so we have the attorneys like Kelly here at the firm who are always available to help with any projects, contracts, any legal matters that a construction company would need. And in addition to that, we also have the Subcontractor Institute. That's an online education platform that we've created where you can kind of go in and teach yourself everything, or the main pieces of subcontract that you need to know. There's 20 chapters that goes into much more depth than some of our webinars. It gives you a lot of information as well, gives you a lot of templates, a template of a subcontract that you can use in your business. So we have different avenues and everything like that for you to make sure that you are being protected and you have a fair agreement to start with, and that you're being proactive in protecting your company and your hard-earned money. All right, well, if we don't have any other questions, if we don't have any other questions, we'll go ahead and wrap it up for today. I know everyone's...
I think there's one more question, Jackie. I'm sorry to interrupt you. Sam's got one more question. It says, let's see, we often get supplied wrong information by the client regarding ground conditions. Blend is flat and smooth and there's weeds. Who's responsible then for delays? And if it's the client's information that is wrong. So again, there's a couple things here, right? That feels wildly unfair. And there's a difference between what is legal and what is unfair. And so, my recommendation in that situation is you do it, you eat the cost to prevent any sort of delay damages. You try to get through it as fast as possible and you minimize that, and then you turn around and sue for misrepresentation, or there's a variety of other causes of action that we might be able to go back against the client for in that situation. Now it would depend on what did you sign your contract in? Was there a situation where we're able to go in and add a clause that gives you extra time if additional land issues come up? So this is one of those situations where we can kind of add preventative clauses to your subcontract. Again, this is specific to only certain trades, right? An electrician, the drywall guy, they don't have these types of issues. So if you're someone that's coming in on the ground floor here and you're doing foundation or land clearing or whatever it may be, and you've been given wrong information, and you can prevent that by take a look at the project, go out there to that address, inspect it, see if you're getting the right information, even disguise it as, hey, I want to make sure my bid's right, let me go see what we're truly talking about. Then you would know these sort of things, to as much extent as you can. Or we try to negotiate different terms that say, hey, any additional work that can be resulting from sloping land, giant weeds, whatever it may be, is going to require a change order. It's going to cost these things. So what we would do in this situation, we can't always guarantee that what we're being told is going to be the truth, but we're going to protect against hopefully bad information. And that would be by being very, very, very specific in what your scope is and contingencies that will either raise your price or raise your lengthen your schedule to prevent you in those types of situations. Or what does the delay damage clause say, and can we make that a situation that also protects you a little more? So this would be something that I would want, to be able to sit down with you, talk to you a little bit about, so we can look at what are these clauses you're typically seeing and how can we strengthen them to truly protect you. Because I agree that, yeah, you're right, it probably is the client's fault, but to prove that is going to be much more expensive for you than trying to protect yourself at the beginning. So that's kind of my recommendation in that situation.
All right, thanks, Kelly. And then we have one last question. Wanted to know, what are common types of insurance policies that are most recommended for types of construction contracts?
That's a good question. So the type of policy is usually just this commercial general liability. That's pretty much the type of policy that's going to be in effect. What would want to be looked at and really negotiated is, like we kind of talked about, is what are the exclusions? You know, does one company maybe exclude something that another one doesn't? Does it include defective work? Does it not include defective work? You know, those exclusions are going to be more important than necessarily the type of policy, because the general liability is really the only type of policy that's going to be applicable to the situations. It's just, you know, how much does it actively cover? You know, can you bump it up a level, maybe pay a little more? You know, it's car insurance. Do you only have liability, or do you want full coverage? It's still car insurance at the end of the day. And so what's excluded, what's not excluded? You know, when I got in an accident, mine excluded rental cost. And so that was a bummer. And so now I've changed that. I pay a little more to make sure that area is covered and not excluded if something were to happen. So it's kind of the same thing, just on a much bigger scale when you're looking at insurance for these types of projects.
All right, thank you, Kelly. All right, well, this was a great presentation. Like I mentioned earlier, I'm going to send out a copy of this presentation after the email, as well as Kelly's contact information, and some information about the firm if you would like to have any other questions or reach out to us. All right, you'll have a good day.
Thanks, everyone. Bye-bye.